Hello, and welcome to episode 38 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director. Joanna is away today. And in today's episode, I'm going to talk about the pressing legal question of whether city bylaw officers can regulate orgies. Buckle up, guys.
Can't wait for that. And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about some of the research I did into the Emergencies Act, and it's actually pretty spicy too. Maybe not as spicy as
I don't know
what Christine's going to talk about, but we'll try. So as listeners know, because we will tell anyone who asks or who's willing to listen, we won at the federal court on our judicial review of Justin Trudeau's decision to invoke the Emergencies Act against the Freedom Convoy. And as listeners also probably know, the Emergencies Act was created in the 1980s in response to a serious backlash that Pierre Trudeau faced after he invoked the War Measures Act during the FLQ crisis in October 1970. And this led to almost 500 people who were mostly innocent being rounded up by police and detained for weeks on end in some cases without access to counsel and without going before a judge, which is a big deal. So our extremely dogged counsel on this file, Sujit Chaudhry, who emails me at the most random times, wanted to know more about the War Measures Act and this whole debacle, since that legislative history might be interesting to the judges who are going to be taking a second look at this case, probably sometime later this year at the Federal Court of Appeal. So before I get into what I found in my research, I want to give you a little brief history lesson for those who don't know. So the FLQ stands for Front de Libération du Québec, and it was a militant left-wing group that emerged in the 60s with the goal of Quebec independence. And these were not nice people. They were terrorists. They had planted hundreds of bombs during the 60s. They actually killed 6 people and injured a number of others. And many had been arrested by 1970. There was a huge raid in June 1970, and there were only a handful of them left by October of that year. But on October 5th, 1970, a small group of them kidnapped British Trade Commissioner James Cross and held him for ransom. And they started leaving ransom notes in various places. They were demanding release of the so-called political prisoners who had been arrested in the summer, and they wanted $500,000. They wanted publication of their manifesto on TV. They wanted safe passage to the communist paradise of Cuba or Algeria, and it was really like something out of a movie. So 5 days later, a copycat cell of the FLQ kidnapped another person, this time Quebec Minister Pierre Laporte, who was eventually strangled to death, although we didn't know this at the time. He tried to escape out of a window. He crashed into it and he was tied up, and he just ended up injuring himself, and then that led to them murdering him. Not nice. So anyway, on October 16th, so early in the morning at 4 a.m., Pierre Trudeau invoked the War Measures Act, which is what allowed him to suspend the civil liberties. And, he used that to round up several hundred people and hold them without going before a judge, which is the right of habeas corpus, to be brought, have your body brought before the judge to make sure that there's some reason to imprison you. And, that dates back to Magna Carta. So that's how big of a deal it is to suspend people's habeas corpus rights. Anyway, as the name implies, the War Measures Act was meant for times of war. And there was one exception, which is insurrections or apprehended or feared insurrections. And what's really interesting is that, Pierre Trudeau didn't have any evidence of a pending insurrection. And when people figured this out, eventually there was a huge backlash. But it's really interesting to just go back through the records and see how it all went down. And it's stunning to me how much what happened in 1970 looks just like what happened with the Emergencies Act under the other Trudeau, Justin, in 2022. So first of all, if you go through Hansard, you'll see just how wily Pierre Trudeau was. So every time the question of evidence of insurrection came up, he would say it was 3 things. Basically, First, it was letters from the province of Quebec and the city of Montreal saying they feared there was an insurrection coming. But the Montreal letter didn't actually say that, and Quebec's letter didn't come with any proof. Pierre Trudeau also cited the kidnappings, obviously, which were bad, but in no way actually portended insurrection. And he cited stolen dynamite and stolen guns, which was probably the most, interesting thing. And, this was bad, but it didn't mean there was an insurrection coming. Like the FLQ had bombed hundreds of times in the prior decade. So anyway, while Trudeau was in Parliament claiming these were the three reasons, this was the evidence he relied on, one of his top ministers, a man named Jean Chrétien, was going around telling the media that they had secret information that couldn't be made public, and there were all these leaks to the media, and the leaks, it was highly implied, were from like Trudeau himself, about secret information that just didn't exist. And when pressed in question period, for example, my favorite response was, so he was asked, like, did this secret information, was that part of your invocation decision? And his response was, yes, no, Mr. Speaker. And then he just like goes off on some tangents. It's like, I don't know how you're supposed to figure out what he's saying there. Also, they had this federal minister, Jean Marchand, who told Parliament that there was an estimated 3,000 or up to 3,000 FLQ members. And a later government report that we found put the official number at closer to 35. So just off by a little bit. And none of this really turned out to be true, except for the dynamite, which was stolen by this like crazy McGill Anglophone student who for some reason supported the FLQ, but he wasn't linked to the original kidnappers. So anyway, the parallels, like I said, to the Freedom Convoy are uncanny. So first, just like Marchand in 1970, Public Safety Minister Marco Mendicino in 2022 went around claiming there was this large group of right-wing extremists planning to violently overthrow the government without providing any actual evidence and leaving people to assume that they did have some secret intelligence that they weren't telling us about. But 2 years later, the only evidence of any real like potential violent threat is what we saw in Coutts, Alberta, where 4 guys were arrested and 2 of them have had their charges dropped. And this was in Alberta. It wasn't in Ottawa, where it turns out there was no, threat of violence. There's no evidence of that there. So another big parallel is pointing to the weapons as evidence of a violent threat. So just like the stolen dynamite and supposedly stolen guns that Pierre Trudeau pointed to, the Justin Trudeau government pointed to this cache of weapons found at Coutts as evidence of some like big shadowy group preparing for insurrection. But police admitted later on that they found no weapons in Ottawa at all. And probably the biggest revelation, and the one that I found the most like striking, was that was the one that we uncovered through access to information, where we got a hold of the formerly top secret in-camera testimony that William Higgett gave to the Macdonald Commission. So the Macdonald Commission was struck in the late 70s, and after it was discovered that the RCMP had been spying on members of the Parti Québécois in the aftermath of the October crisis. And this was outrageous because the Parti Québécois was a political party. So it's like basically the government spying on their political enemies, and they were not violent, even though they had the same aims as the FLQ. And anyway, so Higgett was RCMP commissioner and head of the RCMP Security Service, which is basically the precursor to CSIS, at the time that the War Measures Act came down. So he was arguably like the most important person you would consult if you thought there was like some apprehended insurrection. But Higgett testified, and this was originally in secret, it only came out many years after, that not only did he not know of any evidence of an apprehended insurrection, but he was never asked by the Prime Minister or any other minister at the meetings that he attended in the days leading up to invocation. So he was never asked. And had he been asked, he says he would have said no. He didn't think there was an apprehended insurrection. So obviously this is going to sound familiar to anyone paying attention to this whole Freedom Convoy story, because just like Higgett, Brenda Lucki, who is the RCMP commissioner at the time of the Freedom Convoy, sat in cabinet meetings and emergency committee meetings the days before invocation and was never asked for her opinion on whether the requirements to invoke the act were met or whether there was an emergency. And when really pressed on this at the Rollo Commission, she also said she would have said no. To use her words, police had, quote, not yet exhausted all available tools, which is pretty obvious since a few days later they went in and were able to clear the convoy using the plan that they already had in place. And so the obvious question in both cases is like, why didn't Prime Minister Trudeau in the 70s, Pierre Trudeau, and in the 2020s, Justin Trudeau, ask the RCMP commissioner? And I'm going to go out on a limb here and suggest in both cases that maybe they had already made their mind up and maybe they were going to suspend civil liberties using emergency powers, regardless of whether it was legal. And that's a problem. That's why we think it's so important that we continue to fight this fight, Christine. So thank you for listening to my little lecture on the history of the War Measures Act. What do you think?
It's so interesting. The there's that famous expression, right? That history doesn't repeat itself, but it rhymes. And it's wild to me, this symmetry between Trudeau Jr. and Trudeau Sr. both abusing this piece of legislation in response to domestic political threats. I had an article about this in C2C magazine shortly after the invocation. The article is called Dark Symmetry, or I think it's called Above the Law, the Dark Symmetry of Justin Trudeau's Abuse of Power. And it sort of goes through parts of what you just talked about, like the McDonald Commission that looked into abuses by the RCMP related to the FLQ crisis. The thing I would say is a big difference between them. The War Measures Act is a much more robust, powerful piece of legislation. That's why it was amended because of the sort of the risk of authoritarianism was much greater with the War Measures Act. And that's why the guardrails were put into the Emergencies Act to prevent it from being abused. It didn't stop Trudeau Jr. from then abusing it. But you have to look at the historical context of the legislation when it was enacted and what the legislature was trying to achieve, which is why that research you're doing is so interesting, Josh. The other big difference, I would say, is that the FLQ crisis was much more serious, right? Like there was a person who died. There was no threat of serious violence. There was no violence related to the Freedom Convoy. No one died. The police who testified at the Public Order Emergency Commission or the Rouleau Commission said, I think it was the chief Slowly said it was noteworthy. The protest was noteworthy in Ottawa for its lack of violence. So the FLQ was not nonviolent. They were a violent organization. So that was a pretty big difference as well. Just pretty appalling that the Emergencies Act was invoked in response to a nonviolent domestic protest when the entire purpose of the legislation, when it was repealed and rewritten as the Emergencies Act, was to prevent that very type of abuse. And then it's used on like a much more minor threat relative to what the previous legislation was used for. Anyway, let's get to my news headline, which, as you said, is a spicy one. So brace yourself, Josh. You might want to get a glass of water and make sure you're
covering my ears.
So it's about a man named Matthew Mills who runs a social club in his home in the Silver Springs neighborhood of Calgary. The club is called Club Ménage. I believe a reference to Ménage à Trois.
It sounds very classy.
You can find their Instagram. So if you're interested, I encourage you to look it up. So Club Ménage hosted group sex parties, or colloquially known as orgies. And the participants of the orgies had to purchase a membership in order to take part. Mr. Mills sold tickets to his orgies. So if you have ever wondered how much it costs to go to an orgy, apparently the answer for Club Menage is $30. And that is to cover the cost of preparing his home, because this is all done in his private residence. I will note that the decision does not say it pays for the cost of cleaning up after the orgy, which I would think is the more important part. But I digress. The $30 also covers snacks and refreshments, non-alcoholic refreshments. So all in, I think that's a pretty good deal. That's like you can't have a night out in Toronto for $30. So sounds like a bargain. But in March of 2019, Mr. Mills was given a notice by bylaw officers that his Club Menage was in violation of a Calgary bylaw that prohibits social organizations. This is a land use bylaw. So Mills brought a constitutional challenge to that land use bylaw, saying that his sex club was targeted because of, quote, moralistic and disproportionate enforcement. And now I don't know for sure, but there may be some truth to that. In the judgment in this case, which I'll get into further, but at the beginning, it says, the judge says, many happily attended the orgies, his quote, but that, quote, some of his neighbors looked askance at this activity in a residential neighborhood. So reading between the lines, I think it probably was the nature of the activity that led to enforcement, perhaps based on complaints by the neighbors. Because I do think it's unlikely that the neighbors would have complained if he was running a book club where you paid a $30 fee to cover snacks. I think it was the nature of the activity in this case. So Mills challenged the bylaw enforcement that was shutting down his orgy club. And he said that his freedom of conscience, right to peaceful assembly, and right to freedom of association were being infringed by this bylaw. And on freedom of conscience, you might be wondering, how is an orgy a conscience issue? Well, he argued that he engages in ethical non-monogamy as a core aspect of his lifestyle. And he said this is a philosophy towards sexuality that does not recognize traditional sexual confines of marriage and gender. He also said that his club is not a nuisance. He doesn't sell alcohol at his orgies, although, guests can bring their own, as they can at my house. You can bring your own alcohol. He does not run the orgies for profit, and guests take Ubers or taxis to the orgy. They don't park in the immediate vicinity, so they're not, clogging up the streets. He also said that the parties are no different at the exterior, surrounding and community outside of my private residence than a normal social gathering or house party. It was his use of the word normal, not mine, and no judgment. He said that it's no different from a normal social gathering or house party at any home or residence in Canada. When I have friends and guests over, there is no exterior noise from my home. There is no display of anyone doing anything sexual in public view. The windows are shut, the blinds are closed, and no one from outside my private residence can see or hear what is going on inside. Okay. But nevertheless, bylaw enforcement folks ordered him to stop, and he challenged that stop order at the Subdivision Development Appeal Board, which concluded that Club Menage activities met the definition of a social organization under the bylaw. The case then went to the Alberta Court of King's Bench. And at Court of King's Bench, it was heard by Justice Devlin, who concluded that Club Menage does constitute a social organization under the bylaw, which in some ways is good because now we have some clarity about what a social organization is. The bylaw is vaguely worded, so it's hard to tell if an orgy club or a book club would constitute a social organization. And Justice Devlin clarified that the bylaw prohibits social organizations that are formalized structures dedicated to a thematically unified activity done with regularity at a fixed and dedicated location in a non-gratuitous financial structure. And Justice Devlin also said that the city is entitled to limit the use of residential properties for social organizations. But The bylaw does not prohibit free orgies. So Mr. Mills is free to continue to have his group sex parties at his home, just as long as it's not part of a social club. And Justice Devlin wrote that this limit doesn't touch upon or preclude the use of one's home for the private hosting of social gatherings, including when these gatherings involve individuals who share common sexual philosophies, interests, and activities. So there's actually a very famous Supreme Court case about orgies in Montreal called R and Labay, and that's a 2005 case dealing with the criminal offense of indecency. And in that case, the Supreme Court addressed the question of whether you can prohibit swingers clubs or group sex clubs, consensual group sex clubs, under the criminal law power. And that case involved a club called L'Orage, and it found that swinging is consistent with personal autonomy and liberty, and that swinging does not harm society and should not be considered criminal. In this case, Club Ménage was not dealing with a criminal prohibition, but rather a land use bylaw about social clubs. So these swinging slash orgies or group sex parties can continue, just not under the auspices of a social club. And Mr. Mills' lawyer said that the orgies will continue. Take that, neighbors. But by the way, the lawyer in this case, Mr. Mills' lawyer, is a lawyer named Brendan Miller. And we're going full circle in this podcast because Brendan Miller was actually the lawyer for the convoy participants in the Rouleau Commission. So his lawyer, Brendan Miller, said this law was very vague and there were no guidelines on how it would apply. And now that Justice Devlin has given this great decision that it does apply, yes, my client as a homeowner can continue to have parties, and he will. He will just have to ensure that he complies with the decision. So Josh, good news, bad news. What is your take? What do you think of this?
So this is all news to me. I hadn't read the decision, but it seems like good news, because if you believe in liberty, the government should not be stepping in and regulating your behavior unless you're causing harm to other people. So I feel like they can regulate parking, and these people are not creating, a big parking issue in their neighborhood. But I don't think they should be regulating like the morality of what goes on inside your own house. Something that Pierre Trudeau was famously right about was saying that the state has no place in the bedroom of the nations.
Oh, that quote was in this decision, by the way.
Yeah, I bet it was right at the top. So yeah, I think it's a pretty good decision. I'm all for liberty. I do have some concerns about orgies though, because I've heard some of them charge men $100 to get in and women get in for free, which is obvious sex-based discrimination. And I think someone should take that on as the next
Will you do it,
orgy
Josh?
charter challenge. Oh,
The
maybe
CCF's
maybe
next
it's
case?
the CCF's next case. I don't know. We'll have to pull our donors and see if they're into that, because I know some are very libertarian and others are more into regulating morality between consenting adults, which we don't necessarily agree with. Before I get into too much trouble, let's take a break, and then when we come back, we'll do our bad legal takes.
Great.
Okay, so my bad legal take goes to Emmett McFarlane, our dear friend from the University of Waterloo, who I blocked by him on Twitter, so I don't really know what he's up to, but I picture him walking around the anti-Israel encampment at Waterloo, imploring people to keep their tents 2 meters apart and ensure that their masks are on tight so that they can be safe when they call for death to Israel. Emmett's latest bad legal take is a response to an article in The Hub by Howard Anglin and Ray Pennings about the risk that Justin Trudeau's Senate reforms pose if there's a change in government. And I'll have to explain what they wrote before I get to the bad legal take. As listeners probably know, Trudeau ended the tradition of officially partisan senators and has instead appointed so-called independent senators. But these independent senators are not entirely independent because they're all pretty left-leaning, and Trudeau has tended to pressure them to vote with his side when it really counts. And one of the warning signs for me that they really weren't independent was when Andre Pratt, a newspaper editor who's a very principled liberal, resigned because he said he had been assured by the PM that it would be independent, that he would be independent as a senator, but he wasn't. And at this point, only 13 of the 105 senators are conservative, and they stay on the job till they're 75. So Anglin and Pennings were pointing out that it's going to be an independent Senate for many years to come. So they ask, quote, what happens when legislation from a conservative government runs into a senator's strong ideological commitments? Is there an expectation that senators will, with deeply held convictions, will pass legislation they believe is wrong? Will a senator committed to fighting climate change by any means just go along with a bill repealing the federal carbon tax? And then they go through a number of previous crises where senators in Canada and the UK, rather than doing their job, which is to provide sober second thought and study of bills while not actually blocking eventual passage, since that's been passed by the House of Commons elected by the people. And they worry that the new independent senators will feel emboldened to block more legislation because they're no longer prevented from doing so by being members of a partisan political caucus that would, step in and stop them from blocking bills once it started to make the Liberal Party look bad. In other words, while on the one hand, the Senate now aligns almost entirely with the Liberal Party now has less incentive to call them back from the edge if they're trying to block a future conservative bill. They can just say, well, they're not in caucus, they're independent, they're just doing this on their own volition. Now, whatever you make about Anglin and Penning's argument, it's McFarlane's response that I want to focus on here. It's completely over the top, which is classic Emmett McFarlane, if you know him at all. So he claims that first, it would be legitimate for the Senate to exercise its own powers to defeat government bills where the bills are, quote, blatantly unconstitutional, or where they, quote, represent a quasi-abuse of legislative power. And he says, quote, given Poilievre's recent stated willingness to employ the notwithstanding clause, it would be naive to not to treat some of the predictive doomsaying about the Senate as little more than a preemptive attack on the legitimacy of exercising its powers to prevent rights-violating laws. To be blunt, it's not hard to think that they're concerned that the independent Senate that exists today won't let Pierre Poilievre treat the charter like toilet paper. And this was like a wildly, I think, kind of nasty and unfounded accusation to make about two extremely gentle and principled people. If you've ever met Anglin or Pennings, assuming that's who he's talking about. And this idea that they're scheming about the Senate so that Poilievre can disregard rights, it's not really backed up by any evidence. But the bigger problem with what he says is that he seems to think the Senate could block Parliament if they put forward a bill that the senators think is unconstitutional. And of course, if the notwithstanding clause is used, that renders the bill constitutional. And in cases where the notwithstanding clause isn't used, that doesn't change the fact that disputes about the potential constitutionality of a bill are no different than any other dispute. The principle that this unelected body of elites can, offer their wisdom and study the bills, offer their sober second thought, that doesn't end just because this dispute happens to be about the constitutionality of the bill. And so the proper course would be for the Senate to raise those concerns, propose amendments, and let the bill pass. So Emmett, once again, you get my bad legal take of the week. Christine, what's yours?
So my bad legal take of the week goes to Max Fawcett of the National Observer. He wrote a column recently in the National Observer, just like I guess it's like a left-wing opinion website. So his column said that we need a law against lying in politics, this new phenomenon of lying in politics. Actually, he doesn't say it's a new phenomenon, but I mean, this is just like this hysterical column. And it is so bad. He lists a bunch of lies that he says conservative politicians have said. Breaking news, politicians tell lies. And he does say he's not just concerned with conservative politicians who lie. He says left-wing politicians also lie, although less frequently. And I would love to see the data points on that. Like, I don't know how he's tracking this, but pretty sure that lying is a across-the-board phenomenon among politicians. And he said we need a law to stop politicians from lying. Now, the biggest problem with this, aside from that it's obviously going to be unconstitutional, is that the politicians would have to be the one to pass the law against them lying, which they obviously will not do since they are the ones who benefit from lying and would be punished by this law. So it's just like, I don't know what planet he is living on thinking that this is possible. He does admit that this law that he's proposing may not pass constitutional muster. It would not. And he suggests to get around this that Justin Trudeau should invoke the
Oh
notwithstanding
no,
clause. I don't know if you saw
I
that,
didn't see that
Josh.
part.
Yeah. So I don't know why he thinks that Justin Trudeau would pass a law against lying, which would then, apply to him, or why he would invoke Section 33 for the first time ever in order to pass it. He says the law is important because of, quote, misinformation, at least conceding at this point that it is, in fact, politicians who are the largest spreaders of misinformation. By the way, on the constitutionality of bans on misinformation, we actually had a case about this where we were a public interest litigant a few years ago, where we had a so-called misinformation ban that was part of the Federal Elections Act. We had that struck down as unconstitutional. It was a law aimed at preventing the spread of misinformation about candidates. This is really wacky stuff, Max. I don't think it's even worth paying attention to, because it is obvious that such a law would never be passed, because you would require, as I said, the politicians would have to be the one passing it, and they do not have an interest in prohibiting themselves from lying since they benefit from their own lies. But it's also wildly unconstitutional, in addition to being wildly unlikely to happen. So I'm responding because he did publish this stupid idea. So I will respond to it, but it is a definite bad legal take. That's it for me.
All I can say to that is the allegations in this morning's Globe story are false. Anyway, as usual, we hope you'll rate us, review us, and subscribe. And just a reminder, you can support our work by subscribing to the CCF's YouTube channel, or the Not Reserving Judgment YouTube channel, which is gaining subscribers now that we actually do video. You can also visit our website, the CCF, where you can sign up for our Freedom Update newsletter, where you'll get a list of news stories that we're interested in each week. The CCF is a nonpartisan legal charity funded by your donations, so please click the donate button on our website if you can. Thanks for listening. All right.
Okay.